delve into the legal matters, should we make matters of national scope to be televised, for public consumption and all of that? How about the other discussions from yesterday on the back of the LGBTQI+ bill? Well, joining us right here in the studio, we have Kweku Asante. But before we come to him, let's find out. Let's take you to court and look at some of what happened there.
A preliminary point of law to take with regard to this particular application by way of an objection, and that would be the only ground upon which we would be dealing with this application. And yes, well, there are two ways, but it's actually
you gave no notice of
it. It is.
You gave no notice of it, did you?
Not by way of a formal application.
There was intense back and forth between Thaddeus Sory and Chief Justice Gertrude Tokono, who presided over the panel.
I'm sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of... Please hold on. Don't interrupt me. Please.
Oh, yes, my lady.
Always wait for me to land.
Yeah, I'm not going to say it.
Your substantive application, affidavit before us, is dated the 2nd of April. Listen, let me land. If you had just waited to understand my words instead of rushing to justify yourself, you would have admitted that you didn't have a formal notice to object.
My lady, it is
a lawyer,
yes,
like yourself,
yes,
you found yourself muddled up this morning.
Oh,
yes, you have. A lawyer files. I can see what his difficulty is. When you read, you can see he left out some words. You chose to denigrate what happened in his expressions by describing it as muddled and confused. And the man now wants to correct himself by expressing it fully. And you say you have a preliminary legal objection.
Yes, my lady.
Where is the legality?
The legality lies in the fact that the motion paper invokes the jurisdiction of the court. And if there is an irregularity on the face of the motion paper, which I am pointing out as the foundation to which I am not accepting what he has filed.
No, hold on.
Yes.
Which motion paper?
His motion for injunction.
The man is not seeking... Hold on.
Yes.
Whenever I start, stop.
Oh.
You are going to interrupt me.
Very well.
Then you wouldn't hear what I have to say to you.
Very well, my lady. That once there's an objection taken to it, you cannot overreach that objection with a proposal to amend.
Hold on.
So that's all I'm drawing the attention to.
Stop there, Mr. Stop there.
Yes,
stop there. Now, if you had given a formal notice, anyone would have known. But in your affidavit, you only described your opinion.
No, what I found
that's not a preliminary legal objection.
Well, maybe it is not stated that it's stated as an opinion, but what I was stating what I found objectionable about it. And this court has also said that I don't even need that formal notice, that I can get up when he's about to move and take that preliminary objection. Trustees of the Synagogue Church of all nations. And the strain of them from the court that I didn't need.
Mr. Sorry, I'm not impressed by what you're doing.
Very well,
but just finish it.
I'm sorry. So,
finish it.
So I'm saying that
it's not fair to your friend. I don't think so. But you want to do it, do it.
I'm relying on the authorities from this court to take my preliminary objection, that I'm entitled to take it just when he's about to move it.
So just do it.
And my second point is that...
No, what is your first point?
The Attorney General was not opposed to the application of the lawyers. The court unanimously granted the prayer of lawyers for Richard Alaskai and allowed his application.
Our considered view is that the alleged preliminary objection is unnecessary and does not seek to assist any process before this court. Every party has an inherent right to present the appropriate formulation of their reliefs or other process before the court. The objection is dismissed.
And that was it, dismissed. Well, we have joining us in the studio our very own Kweku Asante. We are privileged. It's an honor to have you join us this morning.
It's good to join Christy.
He reports from Parliament and he also goes to court.
What you trying to do there?
All right, so just walk us through the salient points from yesterday, because there's a lot to digest, a lot to unpack.
So you heard that the Chief Justice make the court's ruling on the preliminary legal objection that Thaddeus Sory, lawyer for the Speaker of Parliament, raised against Richard Alaskai's lawyers' application for leave to amend their reliefs. And the reliefs they were seeking, principally to stop the president from receiving the anti-LGBTQ bill, they muddled up some words and they wanted to correct that. But Thaddeus Sory would take up.
He was pretty insistent.
And insisted that that should not be allowed. He wanted the case to proceed as it was. The Attorney General was not opposed to that application that was filed by lawyer Baidu on behalf of Richard Alaskai. And so the court had to make a determination, and they did make that determination in favor of Richard Alaskai.
We just heard
asking him exactly to actually go and file a fresh motion for injunction, and the lawyers would then respond. We expect that this case may travel up until the end of June or probably beginning of July. If care is
but
not
they were given
taken
till the 17th of May.
17th May, then the two parties will also have 7 days to respond. It's going to June. The concern by some people is that if care is not taken, this may go into July, and very soon there will be legal vacation.
And what that means
and that
is...
will not be heard, and then it's going into November, and then December, then it's election, and all this is not going to be heard. And those are the concerns that people like Dafe Mekpo and other persons who are sponsors of this bill have shared. But there's also the second bit about Dr. Amanda Odoi's case as well. And they also raised concerns about what they considered intemperate language that had been used by Thaddeus Sory in some of the affidavits that had been filed from his law firm. They took great exception to that. The Attorney General also took exception to that. And that is something that the court, presided over by the leadership, the Chief Justice, actually backed and asked Mr. Thaddeus Sory to withdraw and file same. So ultimately, the substantive case having to do with the injunction applications filed by the two parties, Dr. Amanda Odoi, Richard Alaskai, have all not been gone into. The court spent a considerable amount of time, almost 2 hours yesterday, delving into the technicalities of whether or not a person would need the leave of the court to file more affidavits, to review their reliefs and all that. And so that was what the court did yesterday for almost 2 hours, and they had to adjourn the case indefinitely, sine die. And so we expect that when these protests are filed, probably by the end of May, the court will then, by hearing notice, reconvene the parties to hear the substantive injunction motions that have been filed by both parties. And ultimately, the decision can be taken before the legal vacation. That is what the sponsors are looking for.
Some people expected this to happen, for this process to drag to the point where the LGBTQ bill does not receive the signature of the president till another administration comes. Some started forecasting this a long time ago. Others have also asked about the placement of the hearings of the specific cases. Why are we hearing the Alaskai and other ones at this time rather than other motions? What did you gather from court?
So, I mean, what's his name? Sam George was on this show, spoke about what he believed to be a certain sinister plot to actually not hear these cases earlier. We know that the Speaker of Parliament had written to the Chief Justice, just like the Attorney General had done, seeking an earlier hearing of this case. But that was not to be, because I mean, if you look at the timeline, this is clearly not an earlier hearing. This is not an expedited hearing, because these cases were all filed at the end of February or early March, and they are being heard in the beginning of May, and so those concerns have been shared. The Chief Justice is offering no explanations as to why these cases are being heard at this time or not. And in fact, at the time Dafe Mekpo's case against the approval of ministers was heard, I asked the Attorney General whether he was going to be interested in getting the court to hear this matter. He said that he was not the person who filed this case, and he was not interested in whatever expedited hearing that would be. The court would have to take their time and reschedule them. So ultimately, the court now decided to file this case at this point, and they've had the preliminary objections that have all been raised, decided. And then in the next few weeks, we are expected to go back to court again. But like you said, some people expected that there'll be a lot of legalese, there'll be a lot of jargons here and there that will actually destabilize the hearing of the case. And they're probably right, because if you look at yesterday, the court did not do any real work on the substance of the applications that is seeking to force President Akufo-Addo to receive the anti-LGBTQ bill and sign or signify that he's not going to sign it into law.
I'm curious to know how it felt from in there, being in there in the courtroom.
Yeah.
For the first time, most people were seeing the Chief Justice in action. And
Yeah.
so many people critiqued how, hard she was being in the fiery exchanges. Is this normal, or are we just seeing it for the first time, or is this just how it works?
To be very honest, in courtroom, in the Supreme Court in particular, it's almost always like that.
Yeah.
The Chief Justice, Justice Gertrude Tokono, is a very strict judge. For persons who have been in her court before, she's strict. She asks you to adhere strictly to procedure before you get into the substance, because she's of the school of thought that says that the technicalities, that is the procedural law, is as fundamental as the substantive law.
Right.
And so she asks you to do that. So for those of us who've been in her court, we're not so much surprised about that interaction. The bit that got some of us surprised was the fact that, listen, these were a very senior lawyer. Someone like Thaddeus Sory has been practiced for so long. Some of them have practiced as long as some of the persons who are on the bench. And so the expectation was that they will be a little bit soft on all those persons. But of course, the Chief Justice and the bench, they want to be fair to all parties. They want to demand as much from everybody. And like you said, the only 2 times we've seen the Supreme Court inside like this has been the election petition of 2012, held in 2013, and the 2020 election petition held in 2021. Apart from that, there have been no cases that have been telecast live to grasp the nation's attention like this. And so this was a welcoming development for journalists like us who have a difficult job transcribing what is a very legalese courtroom into language that the public will understand. At least this, everybody gets to watch, they get to understand what is going on, and then you can back it up a little bit with some of the things that have gone on. So ultimately, we expect that up until this case will end, we are always going to enter with our cameramen, we are going to video whatever is going to happen there, and then we can see how it goes.
We can count on you and the other members of the team on our legal desk to be there for us. Kweku Asante, ordinarily you will find him reporting from Parliament, but today he's reporting from the courtroom. He also does that, a man who wears many hats. But let's also bring in other guests into the conversation. We have Kweku Painso, he's a lawyer, and then we have Michael Augustus Akagbo. He's Senior Programs Officer with the CDD Ghana, specifically on human rights and social inclusion. Gentlemen, good morning. Starting with Kweku Painso, good morning to you.
Good morning, sir.
All right, it's really good having you. Just a quick one. What are your impressions of the happenings at our Apex Court yesterday in respect of, the LGBTQI plus bill, among others? What are your quick thoughts?
Yeah, I believe it's very welcome in the sense that yesterday was not about a substantive matter before the court. It had to do with an issue of procedure, and I wholly agree with the position that the Supreme Court eventually took by permitting the petitioner, the person who assessed the court, to amend his pleadings or his processes to conform to the reliefs that he's seeking before the court. It's a regular thing that every court is obliged to do, and it will only be refused if they have good reason to believe that the application is not well intentioned. But I mean, it's the time that it took for this matter to be. So I think it's a very quick thing, which is no go to substance. But on the whole, my initial and possibly my final thought is that the Supreme Court did what it's supposed to do. That's my view of what happened yesterday.
And there's also this other point. We'll bring in our other guests on the point, but I also want to find out from you before we proceed. The deliberations, some have said that it was unnecessarily rancorous. What do you make of it? Was there too much rancor, or is this just normal when it comes to the Apex Court and deliberations there between judge and lawyer?
I would confess that I did not watch the proceedings. All the information I've got is what I read from websites like Joy website and all of that. And from what I heard, there was some hot debate between the president of the court, I'm talking about the Chief Justice, and Thaddeus Sory, concerning an issue which the Supreme Court was minded to grant. I mean, honestly, I've not really read the argument that Thaddeus Sory made in support of his opposition to the request that was made. But, I mean, there are certain things that we normally do not even oppose. I mean, application to amend does not go to substance. And the only reason that you oppose this kind of application is to demonstrate that the person, is, what do you call it? Buying unnecessary time, or the person or the application itself is ill-intentioned, and so forth and so on. Because It's a normal thing. Lawyers are human beings. We make errors in everything that we do, and it is very normal for people to seek leave to amend their processes, and leave are normally given as a right unless you can demonstrate to the court that there was an abuse of procedure, and that is to say that the leave that being sought is not well intentioned. So my initial reaction after what I heard in the press or whatever was that intervention or that objection or that opposition was, in my view, with due respect to my learned friend Thaddeus Sory, was totally unnecessary. And I believe that because, I mean, the whole idea is that a person comes to court and all that he's seeking to do by an amendment is to say that what I have before the court in terms of everything that I've had is not intact. In other words, and I mean, the strict procedure in our court is that you can only address the court on what is before the court. And therefore, if at any point in time you come to the view that there's something else that you should have put in there that you have not put in, and then you want the court to see or hear you argue on that point, the normal thing is to, like I'm saying, request for an amendment. And typically, I mean, amendment will normally be given, like I said, until you can demonstrate that there's an abuse of procedure. Because, see, the court is not even supposed to comment on the substance of your application. But the court may hesitate, even if it has to do that. But the point of the matter is that you want to constitute your case. And typically, until the case has run to its logical conclusion, the issue is, if you had run your case along those lines from the beginning, what would have been their procedure? We just have to keep quiet and hear you on your own submissions. At the end of it, then they give their judgment. So, amendments are routinely made, applications for amendment are routinely made, and are routinely granted, subject to what I've said, an abuse and stuff like that.
Right.
So an objection that is founded to the substance of the relief that is being sought is, in my view, my respective view, totally unnecessary. That is my view of what transpired in court with regard to the objection that was taken by the lawyer, Dr. my learned friend Thaddeus Sory. That's my view of the matter.
All right, Kweku, point noted. Please stay with us for a bit. Let me now bring in Michael Augustus Akagbo, who's a Senior Programs Officer and Human Rights and Social Inclusion at CDD Ghana. Michael, thanks for joining the program. Give me a sense of your thoughts on the issue of accepting the media into the courtroom. I mean, the Chief Justice in her speech, when she launched Leading Justice, said that it is meet and right to engage people and let us follow the processes, which is not normal. Do you see any connection here between her leading justice and her objectives and agreeing to the Attorney General's request to telecast these issues live? What do you make of it?
Good morning to the listeners, and good morning to you. Well, I thought that from a personal position that, I mean, it is up to the judge to decide what she does in her court. And I do know that the Attorney General had put in the request citing the fact that it is of a public interest. And for that reason, he wanted this to be telecasted. My only problem I have with this issue is that I kind of thought that it was a more calculated way of trying to change the narrative of what has been going on in the last couple of days regarding issues about the OSP, the AG, and the IOCO on the issues of Japan. So I found it very diversionary that at this moment, when there were serious questions being asked pertaining to certain issues with certain state actors, and when some state institutions were under the microscope of the media and of the public, that we decided that this was the best time we wanted to telecast this event. I thought it was like a red meeting, event.
Well, it's never too late to start, wouldn't you say?
Well, it's never too late to start. That's not what I'm saying. But you see, we find it so convenient when certain things. I'm of the view that I think that a lot of the time LGBT issues have become topical because politicians make them topical. And if you look back in time, anytime we have issues, anytime state actors, political elites are under the microscope of the public, LGBT issues become topical. So I find it difficult to believe in good conscience that this was an actual genuine position of the Attorney General because he wanted to have people listening into what's going on.
Michael, are you saying that this live telecast of this LGBTQ plus proceedings is a way to squash the ongoing brouhaha between OSP, IOCO, and the Attorney General on the stashed money case involving Cecilia Dapa? Is that what you're saying?
Since yesterday, have you heard anybody talking about that event? Nobody else. We'll be also focused on this very issue because we brought the television into our home. And what we do is that when we do that, we divert attention of people from the real issue we need to be focused on.
But are you suggesting that these issues are not important as well? Because some would also say, these are crucial issues as far as national life is concerned. I get the point you're making. Sometimes it is used or it could be used as a form of distraction. But does it take away from the essence of it as far as our national life is concerned?
No, it doesn't. But the point is that we have been in court since last year. We have been in court since last year on this very case. So why do you decide at this particular moment this is when you want to telecast this proceedings?
I see. And a quick point, though, for those who have said that there are some attempts to make this drag for as long as possible so that the bill will not be signed into law and it will also continue to then feed into what you are talking about, take away from some of the other crucial issues we ought to be looking at. What is your thinking? Some people feel the courts, everything happening, not getting the president to sign it and all that. It's strategic. It was planned. Do you think so?
Well, I wouldn't say that. I do know that depending on what the court calendar is and how and when they decide to take up their cases. So I will not impute that level of machination to say that the judges or the court is in connivance in a way to want to drag this issue out. I think that we need to allow the courts to do what the courts are mandated to do. I have said it earlier in some spaces that the beauty of the executive court is that it's a mechanism to test the law. So that is what we are doing. Right now, some people want to get judged or declaration for whatever reason. It's not reason for us, the judges, to take up the case if they are not ready to take it up.
Okay, please hold for me. Let me bring back Kweku Penso. Kweku Penso, do you agree with these assertions that Michael Akagbo is making about the issue of silencing the ongoing Cecilia Dapa case with this live telecast of the anti-LGBTQ proceedings in courts? What do you make of it? I
totally disagree with mine. What he needs to know, first, he needs to appreciate that the issues are in different courts. Cecilia Dapa's case, as far as I know, is pending in the High Court. And there are many high courts in Ghana.
Mr. Painter, I don't think it's the courts where it is that he's referencing. He's referencing the attention.
No, I'm trying to provide a justification for why it is easy for the Supreme Court or for the Attorney General to request that a matter before the Supreme Court should be telecast. I'm just trying to provide a reason. Why the Supreme Court is just one court. But then, the truth of the matter is that who chooses what is in the national interest? I think the late Professor Ansa was the one who used to say, let's be thankful for, small mercies, that we receive. The truth of the matter is that this business of telecasting matters before the court, first and foremost, justice is administered in the name of the people of the Republic of Ghana. Our courts are open courts. And it's not every matter that, of course, attracts the attention that it requires for everybody to be so much interested. But somebody has to make a choice. And the way I will react to what the Attorney General has done is that we are thankful to God for small mercies. Nobody is going to say that because he said the past matter is in court and this matter is also in court, or every political matter is in court, every political matter that is in court ought to be attended by TV cameras and whatever. There are a lot of political matters that are in court. What will become the basis for determining But at least we have this matter which is in one court, and the Supreme Court is the highest court in the country. And I would say that what the Attorney General has done is in the right direction. It fulfills the demands of justice that the people must not only hear, they must also see what is done.
I have a quick question for you. I have a quick question before.
Resources and everything to open the court up to all of these things. So I would say that I totally disagree with what my good friend is trying to suggest. I mean, with due respect, it's a form of insinuation. And I would rather be grateful to the Attorney General for the small messages that we are getting.
Okay, so that point is made. That point is made. Just a quick one. This matters of national interest. It's like an open field. Which matters are of national interest that you feel should fit into this? Because then you ask yourself, so which issues should be televised and which ones should not?
There is no criteria for determining what must feed the national interest in terms of it being telecast and so forth and so on. It has to be a decision of some sort. But as it is now, we are looking now, it appears to me, at decisions that have political implications for this country. And Sisadapa is one. I've known of other matters that have also running in the High Court of cases, even though our criminal trials also feeds the political spectrum or the political arena. I'm talking about the case, what do you call it? This fertilizer matter, and so forth and so on. So I will leave that decision to the Attorney General. He may determine which cases, in his view, is best suited for live telecast. And I think that it's very appropriate that in the constitutional matter of this nature, Ghanaians are given the benefit of the courtroom experience. For now, that we have not derived a criteria, or we have not formulated a criteria for determining which matters must receive telecasting and so forth and so on, I'm comfortable with the Attorney General using his discretion. If anybody believes that there are certain categories of cases that ought to be telecast by reason of their importance or by reason of the national interest, let us formulate a formula for that. But for now, I'm content with the decision that Attorney General made, and I will not accuse him of bias or any any other interest. I will not.
Thank you so much.
I don't think the point was to accuse him. Thank you, Kweku Pinto. But that was not the point. It was just to find out. So what do you think fits into that area? But thank you, Kweku Pinto, for joining the conversation. Sweetie?
Kweku Pinto is a private legal practitioner. We also, Michael, if you have some final words, please do that in 30 minutes, 30 seconds where we can go.
So I was going to say that I disagree with Kweku Pinto's position. And as somebody who has studied extensively the history of LGBT in this country, I find it difficult to believe that it is just when they act that the LGBT issues come up issues. So I find there's a strong correlation from previous events.
Mr. Akagbo, you would have to Mr. Akagbo. Hello. Please reposition. We are struggling. The line is patchy, so we are not hearing anything you're saying. Please reposition and start again so that we can hear you better.
Can you hear me?
Yeah, it's better now. Please go ahead.
Okay, so I said I disagree with Mr. Benton's position, and then that is because having studied the history of LGBT in this country, I always find it interesting that every time states acted, our political elites are somehow under the microscope of public scrutiny, LGBT issues become topical. You can go back in time. You can look to all the times, like, for instance, when we had the emolument recommendations for the president's wife, when we had the issue of, I believe, it had to do with the e-levy. All these times, LGBT issues became very topical issues to change the conversation.
All right. Your point's been made.
That is why I find it difficult that this is not another way of changing the narrative of what is ongoing.
Thank you so much, Michael Augustus Akagbo, who's Senior Programs Officer with Human Rights and Social Inclusion at the CDD Ghana. And that's how we're wrapping up for this belt of our conversations on the M Show.